So, the Supreme Court just dropped an 8-1 emergency ruling on the Second Amendment that nobody saw coming, and it's going to reshape gun rights in America for the next decade. What happened here is not what anyone expected. The justices, who have been the strongest defenders of gun owners for years, just voted against them. And only Clarence Thomas stood his ground. Before we break down exactly why this ruling could threaten every gun rights victory since 2008 and what it means for 50 million AR-15 owners across America, make sure you hit that subscribe button right now, because this analysis is going to show you what the mainstream media refuses to explain about how the courts are quietly rewriting the Second Amendment. The vote that broke the conservative alliance. The 8-1 vote on this emergency application reveals a fracture in the conservative Supreme Court that gun rights groups never saw coming. Justices Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett all sided against gun owners, despite being appointed specifically because of their Second Amendment records. These three justices have voted together on gun rights in 94% of cases since joining the court. But this time, they abandoned that pattern without explanation. But here's what changes everything about this vote. The timing of this denial came just 3 weeks after internal Supreme Court documents leaked, showing the justices had conferences scheduled to discuss taking up 4 different Second Amendment cases. Which means they might be planning something bigger that required them to stay silent on this emergency request. The Maryland ban that rewrites constitutional history. Maryland's assault weapons ban doesn't just prohibit AR-15s. It bans 45 specific firearm models by name, and then adds a catch-all provision that bans any semi-automatic rifle with just 2 common features like a pistol grip or adjustable stock. This means a standard hunting rifle becomes illegal the moment you add an ergonomic stock that helps disabled shooters. And manufacturers can't design around the ban because the features listed are basic mechanical components. The law was passed in 2013 after the Sandy Hook shooting. But what most people don't know is that Maryland's own state police data shows these banned rifles were used in less than 2% of all gun crimes in the state over the past decade. But there's a data point buried in the court record that nobody's talking about. Maryland prosecutors admitted during oral arguments that they couldn't cite a single case where the banned features made a rifle more deadly in an actual crime, which means the ban is based on the appearance of firearms rather than their function. The Bruen decision courts are systematically ignoring. The Supreme Court's 2022 Bruen decision was supposed to be the most significant expansion of gun rights in American history, establishing that modern gun laws must have historical analogs from the founding era to be constitutional. Federal courts were ordered to stop using interest-balancing tests that weighed public safety against individual rights, and instead apply a strict text, history, and tradition standard. But here's what actually happened after Bruen was decided. A Stanford Law Review study published in September 2024 analyzed 118 federal court decisions on gun laws issued after Bruen, and found that gun control laws were upheld in 71% of cases compared to 68% before Bruen, meaning the decision actually made almost no difference in outcomes. The Fourth Circuit's decision in the Maryland case took this even further by ruling that if a weapon is like military weapons, states can ban it even if it's in common civilian use, which flips Heller's framework completely backward. But the data shows this isn't just a Fourth Circuit problem. 8 of the 13 federal circuit courts have now adopted similar reasoning to uphold gun restrictions after Bruen, creating a nationwide pattern of judicial resistance to the Supreme Court's clearest gun rights precedent. The common use test that protects nothing. Justice Scalia wrote in the Heller decision that the Second Amendment protects all weapons in common use for lawful purposes, and specifically noted that M16 machine guns could be banned because they're not in common civilian possession. That standard should clearly protect AR-15s, since over 24 million are in American homes, making them the most popular rifle platform by an overwhelming margin. But federal courts are now claiming that popularity doesn't matter if the weapon shares characteristics with military firearms, even though every firearm technology, from revolvers to bolt-action rifles, was originally developed for military use. A George Mason University analysis found that if courts apply this version of the common use test consistently, approximately 78% of firearms currently in civilian hands could theoretically be banned because they use technology or features that weren't available at the founding. The analysis pointed out that modern handguns with polymer frames, striker-fired actions, and high-capacity magazines would all fail the historical test, despite being the most common firearms for self-defense. The circuit split that's coming faster than anyone expected. The Fourth Circuit's ruling creates an immediate conflict with the Fifth Circuit, which struck down Texas's under-21 handgun ban in 2023 by holding that modern popularity defines common use, not founding-era analogs. These two circuits are now applying opposite standards to the exact same constitutional test, which typically forces Supreme Court review within 18 months, according to empirical studies of cert grants. That means gun rights advocates are almost certainly getting a definitive ruling on assault weapons bans by June 2026. And the composition of that decision could determine Second Amendment law for a generation. Justice Clarence Thomas has been assigning himself to write opinions in Second Amendment cases at an unusual rate, authoring 4 of the last 6 major gun rights decisions. And legal observers believe he's building toward a comprehensive opinion that addresses these circuit splits all at once. The originalism crisis that threatens the entire conservative legal project. This case exposes a fundamental problem with originalist constitutional interpretation that goes far beyond gun rights, and it's causing a quiet crisis in conservative legal circles. If the Second Amendment only protects firearms technology that existed in 1791, then logically, the First Amendment only protects printing presses and town square speeches, not internet communication or broadcast television. A 2024 Harvard Law Review article surveyed 200 federal judges and found that 68% of judges appointed by Republican presidents believe originalism requires limiting constitutional rights to technologies the framers would recognize. While 89% of judges appointed by Democratic presidents, this divide is creating inconsistent rulings across every area of constitutional law, not just the Second Amendment. The Supreme Court's refusal to clarify this issue in the Maryland case suggests the conservative justices themselves are divided on how to apply originalism to modern weapons, and that internal disagreement is paralyzing them from taking cases that would force them to choose between strict originalism and practical gun rights. But the political stakes make this even more complicated. Conservative legal organizations like the Federalist Society built their entire judicial philosophy on originalism. And admitting that originalism can't protect modern firearms would undermine 40 years of constitutional theory that these same organizations used to reshape the federal judiciary. If this Supreme Court ruling has you concerned about the future of the Second Amendment, hit that subscribe button and turn on notifications right now, because this case is far from over, and the next 18 months will determine gun rights for the next generation. Drop a comment below and tell me whether you think the conservative justices are deliberately avoiding this case because they're divided on originalism, or if they're waiting to strike down every assault weapons ban in the country with one massive ruling